Okay, we are live. Welcome to Litigate on Fire. I am attorney Amanda Schaefer. This is episode number 2, continuing child support challenges in the New York family courts. Before I get to the episode, quick reminder, don't forget to like us on Facebook, YouTube, Instagram, wherever you are watching. So, let's start with a quick recap of what we talked about in episode number 1. This came out of some frustration I was experiencing with a case, a child support case. And I'm going to give you the basic facts so we're all up to speed. Client was appearing pro se. He missed court back in March of 2022. The time he lived in Egypt, and a few days before his court, there's daylight savings time in the US. Hours you spring ahead. It went ahead an hour. He didn't realize it because he was in his native country, where they did not have daylight savings times actually until this year. So he missed court, and court entered a default order against him. And the amount that they entered the child support against him was not what he was earning. At the time, he was back in his country waiting for his H-1B visa. The petition was approved, but he was waiting for the consulate to open because it had been COVID. And so he had just been waiting to get his H-1B, come back here, and work his H-1B job. The problem was that the default order was based off of the salary he would have made as an H-1B employee, but there's a huge income disparity in Egypt. It's like a tenth of what you would make here in the same profession. So he couldn't really make the same money, and he fell behind child support, and his arrears got piled up. He didn't even know because they were sending notices to a U.S. address, even though he told the court he didn't live there. And he comes back to the country, finds out they're going to suspend his driver's license. He was past the date for challenging it, even though he tried to challenge it, but the Child Support Collection Unit, or CSU, said it's too late, so we're not treating this as a challenge. It's a correspondence. You gotta pay, basically. So he wrongfully filed an objection to the default order. It wasn't his fault. You didn't know. The objection actually was granted in one specific part for the judge to explain why they didn't consider his business expenses, but otherwise they wouldn't vacate the default order. Because the correct procedural mechanism would be a motion to vacate, which he then did file within a year of the order. That had been pending. He then, when his driver's license actually got suspended and he lost his job, he had to find another H-1B job, which he was lucky that he did because his job required him to drive to different work sites. So you can get a restricted driver's license if your driver's license is suspended due to failure to pay child support, but you can only drive to one work site and home. So that wasn't going to work for him. So we filed an emergency order to show cause to have the court order CSU and DMV to lift his driver's license restrictions and issue him a full driver's license again so he could do his job and pay his child support. So we did that, and the court granted it. They granted the motion, and actually we were able to get the other party, the mother of the children, to agree, because the reality was that he couldn't just work at Starbucks or Home Depot or McDonald's, because he had to work in an H-1B job or he would be in violation of his status, and then he'd never be able to afford the child support. So we were excited about it, but then he went to the DMV and showed them the order, and they said, no, they can't tell us to do this. And we were like, okay, not really sure how to handle them denying it. But then a few weeks later, end of recap, Child Support Collection Unit, or CSU, filed a motion to vacate. They said that two things. One, that my client did not exhaust his administrative remedies, meaning that the law sometimes says that before you can ask the court to review something, you first have to, jump through the hoops, follow steps A, B, and C. And in this case, he was supposed to challenge their suspension order. And if CSU then denied the challenge, he could have then objected in family court. But as I said, they didn't accept his challenge. In fact, we filed a second challenge when we found a provision of law that said if you did not receive actual notice of the challenge like he did and you prove it, which he did, then you can challenge it at any time. And they still wouldn't accept it. So we actually tried to challenge it twice. So the court agreed with that on us. And then the other thing was that CSU said, well, that's great. Even if he exhausted administrative remedies, the family court does not have jurisdiction to tell CSU what to do. That state law and federal law and administrative law all vest this authority, enforcement authority in CSU, which is true. They're the ones who, if you pay child support or someone pays child support to you and it's not paid to you directly and it goes to the state, they collect the money and then they pay you. So they have a lot of different enforcement mechanisms at their hands, at their fingertips, including suspending a driver's license and another professional license, such as an attorney license or a medical license. They can take your tax refunds. They can do income executions. They can seize assets, bank accounts, lots of different things they can do. In this case, they decided to suspend the driver's license. But I had said, even initially when I filed the order to show cause, that there is a statute in the Family Court Act, I think it's Section 454, but don't quote me on that, that says that although the family courts are courts of limited jurisdiction, meaning they can only do what the legislature has told them they can do, they are allowed to vacate orders. They're allowed to modify. They're allowed to do a lot of different things if it's in the interests of justice. And in this case, it seems pretty obvious it was. Why? Because this is a person who's in this catch-22. He gets his driver's license suspended, loses the job that he can work legally in the U.S. on. He then, if he goes back to his country, he won't earn that money. That's in the child support order. They won't lift his suspension because he owes the money. But he can't pay the money until the suspension is lifted and he can get the new job. So it's just kind of going back and forth. And that's a good place for the court to step in, especially we explained in the motion about his immigration status and the fact that he really did. It was really, despite that we're still fighting this fact that he didn't intentionally miss court. He had a reasonable excuse or excusable neglect, however you want to put it. Even though some of the other support magistrates didn't find his story to be credible for whatever reason, we are currently appealing that. But again, the arrears are still piling up. Every month he owes child support based on an amount that he doesn't come close to earning. So I was happy to say that the judge granted the motion, or not granted, we didn't file the motion, denied the motion in the entirety, saying that they do have the power to correct wrongs against innocent people when it's in the interest of justice, just as I said. It is not a final decision. There's basically CSU has 30 days to object. Will they object? Wouldn't put it past them. I'm hoping not, because I really do think the law is on our side now and it would just be a waste of time and energy. So now what is the question? we still have arrears. Arrears, like I said, thousands, tens of thousands of dollars piling up. And again, that's why the driver's license got suspended. The family court, unfortunately, cannot vacate the arrears without vacating the underlying order. That's one of the powers they don't have, unfortunately. And that's why we're in the middle of appealing. We have 2 appeals going right now, based on my client wasn't told he can have an attorney, and based on the fact that he really didn't mean to miss court. He had a good defense. He told them about his defense. He submitted paperwork in advance. He went to the other previous court hearings and contacted the court immediately within an hour of missing it when he thought he was trying to get into the virtual courtroom and they wouldn't let him in, only to find out they already issued the default order. So we're really hoping now we just got the order. He's going to take it to the DMV. Hopefully they lift his driver's license suspension and he can find a new job. I know he's here visiting and has to go back, but he's hoping to get the driver's license first. So what does this all teach us? Well, number one, litigation is frustrating. But you got to keep fighting. You got to keep going. When you know you're right, you got to stand by it. And I'm very confident in our position here. I was, as happy as I was when this all went down last week, I wasn't as happy as I normally am when I win, just because I knew it wasn't over for the client. Sometimes I know it's not over, and at least we can have a moment to breathe. But that's how I felt when the family court first granted our motion to lift the license. Then all of a sudden, child support collection unit steps in, and it's been 8 or 9 months since we first filed the motion. I mean, it's insane how long these things take. So I'm just kind of holding my breath, waiting to hear. But yeah, litigate on fire for sure. I mean, no one should have to go through this. And, this is a guy who really does want to pay the child support amount. And he just wants it fair. He also has a modification petition pending. We were able to get the judge to cut the amount he has to pay a month in half. It's still way too high based on the fact that he can't work right now. So we will be having a hearing on that in the future. And then hopefully, really, I'm going to be submitting this appeal this week, at least the first appeal. And hopefully the appellate division agrees with us, vacates the order, remands it for a new hearing, and then he can be given due process and a chance to present his case. That is all for now for Litigate on Fire. Thanks for watching episode number 2. Don't forget to like us and follow us on Facebook, YouTube, Instagram, wherever you are watching. If you know someone who may find this helpful or you did yourself, click that share button, that save button, or leave me a comment. Let me know what you think. We'll be back next time with episode number 3. It may or may not be the same case. Still filling out this series. So again, drop a line in the comments. Let me know what you think. And if you need an attorney for family or immigration, our contact information has been scrolling across the bottom of your screen. Please feel free to reach out. We look forward to helping as many people as we can. Thank you all for watching and have a great day.